Hi everybody, it's Mike Kennedy from Bar Council. Back on the video. I'm going to try to get back to that a little bit, sort of got away from it. But I hope to share some that I also hope will be helpful to lawyers and people who work in law offices and law firms. First, you'll notice that in my office, not on my deck, which is where I film most of my videos. I wish I was on my deck. It's absolutely beautiful morning for that to be out there with a cup of coffee, but I'm not. Had to get up and get the car to the garage this morning early. Then I came to the office, so I'm not at home, which means I'm not on my deck. Although if I were, and I know this is not why you tuned in, but I'll get to the legal ethics topic in a moment. If I were, it probably would demonstrate a lack of confidence on my part. My flowers have not done well. They did great early in the summer. They're sort of not doing well now. And I think it's my fault because when it rains, and it's rained off and on a little bit over the past week, I feel like my gut instinct is that's enough water. So I don't do my normal watering. My mom was telling me that that's not the way to go, that sometimes it rains, but it's not nearly enough, not enough water for the plants to thrive. And I want my plants to thrive. So, but I think that not watering on the days it rained over the past week cost my plants significantly because they don't look too great right now. Maybe they'll come back. We get a little bit of time. We'll see. Anyway, I hope to be back on the deck soon. But for now, I want to talk about, I mentioned it in the blog post that accompanies this video. I feel like once Labor Day passes, it's kind of like back to school time. So I want to start today and this week with some of the basics, not just the basics of legal ethics and professional responsibility, but also addressing some of the basic misconceptions, some of the more common misconceptions that I think lawyers have when it comes to their professional obligations. And one of the more common misconceptions that I encounter when interacting with lawyers who have ethics inquiries is the way that lawyers go about analyzing potential conflicts involving former clients. It's very, very common for a lawyer's initial reaction, getting a new case and realizing that a former client is going to be involved and will be adverse to the potential new client. Lawyer's typical reaction is, well, I don't remember anything about the former client's matter. Therefore, no big deal. I'll take the new case. I get it. And I don't distrust that you don't remember anything about the former client's case. That, however, is not the test. The issue is not what you remember. The issue is applying the rule as it's written and as it's stated and what the Vermont Supreme Court has said about the rule. And if you look, nowhere in the rule does it take into account what you may or may not remember. And in fact, the Supreme Court has addressed that exact point. But let me first start with the rule that when it comes to former clients, our duties are set out in Rule 1.9. And more specifically, when it comes to conflicts of interest involving former clients, our duties are set out in paragraph A of Rule 1.9. And here's what paragraph A says. A lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. So the first question is whether the two matters are the same or substantially related to each other. No, stated differently, the first question is not whether you remember anything about the former client's matter. Are they the same or substantially related? Usually it's pretty easy to determine if the matters are the same. It can be harder to decide whether the two matters are substantially related to each other. The comment to Rule 1.9, or excuse me, a comment to Rule 1.9 says, matters are substantially related for the purposes of this rule if they involve the same transaction or legal dispute, or if there otherwise is a substantial risk that confidential factual information, as would normally have been obtained in the prior representation, would materially advance the client's position in the subsequent matter. So pretty broad, right? And that's how it's supposed to be. That's how the rule was meant to be interpreted, and that's why it was drafted as it was drafted. In fact, long ago, case I handled when I was barely a lawyer, well, I was a full lawyer, but I hadn't been a lawyer for very long. Because as you know, there's no such thing as barely a lawyer. You're a lawyer, you're not. The Vermont Supreme Court stressed that this rule, Rule 1.9a, the exact rule we're talking about, is a prophylactic rule that is intentionally brought to ensure that a lawyer does not use confidential information acquired from a former client against that client and to avoid even an appearance of impropriety. And that's where lawyers tend to apply the wrong analysis, because they think, well, Mike, there's no chance that I'm going to do what the court says is the risk. There's no chance that I'm going to use confidential information acquired from the former client because I don't even remember anything about the case. The court has said that doesn't matter. What the court has said is this: if the prospective new case, potential new case, is substantially related to the case in which you represented the former client, we are going to presume that you received confidential information of the type that ordinarily would have been shared when representing a client in that type of matter. And not only are we going to presume that, it's an irrebuttable presumption when the two cases are substantially related, because we're not going to allow you to say, I don't remember, because then what we do is we put the client in the position of having to disclose the confidence in order to protect it. And we're not going to do that. So keep in mind, again, I don't doubt you when you say you don't remember anything about that case. We've all had so many cases and time has gone by. So I don't doubt you, but that's not the test. The first step is this case substantially related to or the same as the old case? If so, it doesn't matter what you remember. You are presumed to have received confidential information, and we're not going to make the former client disclose it to protect it. So that's today's tip. The rules are more broad than that. There's another clause that I'm not going to address in this video or in today's post. I've addressed it in other posts that I've linked to at the bottom of today's, but I'll stop there. Hope you're all doing well. I'll be back again later this week, I hope, with some other videos and perhaps even from the bright sunny deck, where I will make sure that you don't see my flowers that have been incompetently tended to over the past week or so. Have a great day.